Good morning. My name is Eric Tonsul. I'm one of the shareholders in the POA section of RMWBH's POA department. Today I'm going to be talking to you guys about board meetings 201. So saddle up, let's go. A second here. First and foremost, the information presented today is based on the law as it exists as of today, August 16, 2022. Information presented for educational purposes and does not constitute legal advice. If you need any legal advice relating to any of the topics discussed, please consult your attorney. So before I get into the goals and the rest of the presentation, I want to say that we do have the chat function open on the Teams meeting. So if you have a question, please type your question in the chat box. Kyle will be monitoring those questions. I typically take the questions at the end of the presentation, just so it doesn't disrupt the flow. But I will answer as many questions as I can after the presentation is done. So by all means, if you have any questions during the presentation, please feel free to enter it into the chat box and I'll get to as many as I can. So the goals of today's meeting, or presentation rather, I'm going to be talking to you guys about action items at board meetings, and talk to you about meeting minutes, the executive session, and virtual meetings. So those are the four main topics that we're going to be covering today. So first and foremost, open meetings. So open meetings, board meetings for single family and for townhomes must be open, and condominiums as well. The requirement for this for single family and townhomes is in 209.051C of the property code, which says that a board meeting must be open to the owners. Owners must receive proper notice of the meeting, subject to the board's right to adjourn to executive session to discuss certain topics. We'll get into that a little later in the presentation. And then for condominiums, the open board meetings requirement is in 82108B of the property code, which again, subject to the board's right to adjourn to executive session. So as a point of clarification, for those who may not know, single family residential associations and townhomes are subject to chapter 209 of the property code. For condominiums, it's chapter 81 and 82 of the property code. 81 applies to condominium associations where the declaration was recorded prior to January 1, 1994. Chapter 82 is applicable to condominiums where the declaration was recorded January 1, 1994 and forward. Now, there are some provisions in Chapter 82 that are applicable to Chapter 81 condominiums. So just you're aware that if you're in a pre-1994 condominium, there are some portions in Chapter 82, which is commonly referred to as the Texas Uniform Condominium Act, or TUCA, that are applicable to Chapter 81 condominiums. So let's talk about action items at board meetings. When we have a board meeting, there's obviously a myriad of different topics and issues that are discussed at board meetings. And this is just kind of a highlight of some of the items that are typically found on the agenda for a board meeting and the action items therewith. Preparing and adopting budgets, operation and maintenance of common areas and common elements. Little point of clarification, common areas typically refer to the area the property that's owned by a single family association or a townhouse association. Common elements applies to condominiums, and those are not owned by the association. They're owned pro rata by the owners of the condominium. We also discuss in action as a board meeting, maybe hiring personnel that's necessary to operate the association. Adopting or amending dedicatory instruments for property. And when I say POAs, I typically am referring to Chapter 209. If I'm talking about condominiums, I'll say a condominium association. So for POAs, Chapter 209 specifically requires, and it's in 209.051H of the property code, that says that if you adopt or amend a dedicatory instrument, it must be done at an open board meeting. And so what is a dedicatory instrument? Those are your bylaws. Those are your declaration, your rules and regulations, your policies, your guidelines. Those are examples of dedicatory instruments. Now, with your declaration, it typically requires a vote of the owners. That's different. Boards typically do not have the authority to unilaterally amend a declaration. In fact, 209.041 of the property code specifically says that the declaration must be amended by at least 67% of the owners. Condominium is a little bit different. It's in 81.111, I believe, in Chapter 81, and 82.067 of TUCA for Chapter 82 condominiums. You also might want to talk about contracting for services or maintenance or repairs. That's where you're selecting vendors to handle situations in the association. your security contracts, your pool vendor, your landscaper, those kinds of things. Teaching note here, for those that may not be aware, there was a lot of new laws that went into effect last year, effective September 1st. And one of those new laws pertained to bid solicitation for, again, this is only applicable to Chapter 209 associations, not condominiums. And for single-family POAs and townhouse associations for contracts over $50,000, you must solicit multiple bids for proposals using an established bid process. Now, this does not apply during the development period of an association. So if an association is still developer controlled, this $50,000 requirement is not applicable. And to be clear, this does not mean if you solicit multiple bids, you are not required to select the lowest bid. It does not say that. That's not what the statute says. It simply says that if you have a contract for services that's going to be in excess of $50,000, you must solicit multiple bids. And again, the statute also says by a bid process that's established by the association. So for you associations or the associations that I represent and our firm represents, we've been preparing a 209 bid solicitation policy. If you have not already adopted one of those, I strongly encourage you to contact your legal counsel because, again, it is required per the new law. And lastly, another example of an action item for a board meeting is engaging experts for guidance and decision-making to protect POA assets. Whether that be contacting your legal counsel, whether that be engaging an engineer to, evaluate the structural integrity of whatever in your association, in your common area, whatever it may be. Those are the kind of things that are examples of action items that would occur at a board meeting. So in Chapter 9, 209.051H, there are 15 things that must be considered and voted on during the open session of a board meeting. In other words, you cannot do it via email. You cannot do it over the phone. You cannot do it via Zoom. You cannot do it via text message or whatever else. It must be done in an open board meeting for which proper notice is given to the owners. I know what I was going to say. Also cannot be done during executive session. It must be done during the open session of the board meeting. So these are the 15 things that must be done in an open board meeting. I'll just read through them very quickly. Levying fines, levying a special assessment, setting the annual budget or an amendment to the annual budget. That's a change due to the new law that just went into effect last year. Previously, if it was a change that was going to increase it by more than 10%, then you had to do it in an open board meeting. Now the law says any amendment to the annual budget must be voted on and adopted at an open board meeting. Damage assessments, ACC appeals. This is an important one. A lot of those are done typically. Boards don't understand or realize that if the ACC denies an owner's ACC request and the owner appeals the ACC's decision to the board, that appeal hearing must occur at an open board meeting, unless the owner requests that the hearing be held during the executive session. In that case, you can make the exception and have the ACC appeal during the executive session. Sale or purchase of real property, initiation of foreclosure action. That's if you're turning over an account to your legal counsel to proceed with collection activity, that must be done during the open board meeting, not in the executive session. I will get more into that later on in the presentation. Suspension of an owner's right. If an owner is delinquent, they are not automatically suspended from, for example, gaining access to the pool. The board has to make a vote to suspend that owner's privileges to use the common areas. Now, it's very important that, again, that's not automatic. You have to have the authority in your governing documents to suspend an owner's right to use a common area for a violation of the rules or non-payment of assessments or whatever it may be. But it's not automatic. The authority has to be in your governing documents. So make sure that if you are suspending an owner's use of the common areas, that authority is in your governing documents. Filling of a vacancy, that's a vacancy on the board. For example, a board member resigns because they're moving out of the neighborhood. The board has the right to appoint a new director to fill that spot, and the term will be the rest of the term of the retiring board member's term. So, for example, Mr. Smith has 1 year left to go on his term. he resigns. You appoint Mr. Jones, the board appoints Mr. Jones to fill the vacancy. Mr. Jones will serve for that 1 year left on that term. And at that point, that position will then be up for election. Initiation of enforcement actions. Those are your DRV, your deed restriction violation enforcement actions. Again, I'll get into that a little bit later about what that entails. Lending or borrowing money, if the association is going to lend or borrow money, a loan, for example, that vote must be done at an open board meeting. But again, that's not an automatic right. You've got to look at your governing documents, because in some instances, in order to, for example, take out a loan or pledge the association's future assessments as collateral for the loan, that may require a vote of the owners in order to do that. So again, if your board is looking to potentially take out a loan, make sure you give your legal counsel and make sure you have the authority, what the approval requirement is in order to take out a loan. The construction of capital improvements. Again, this does not include repair or replacement of existing capital improvements. This is the construction of new capital improvements. For example, if you guys wanted to build a tennis court, you didn't have a tennis court in your neighborhood, that would be something that would have to be voted on and approved at an open board meeting. And again, look to your governing documents, maybe something that may require a vote of the owners as well. If you're going to increase your assessments, that is something that must be done at an open board meeting. If you're going to adopt a dedicatory instrument, that must be done in an open board meeting. For example, you want to adopt a short-term leasing policy. That would be something that would have to be voted on at an open board meeting, for which proper notice is given to the owners. And lastly, the election of officers. This is one that often gets overlooked. So you have your annual meeting. Let's say you had a 5-member board. Let's say 2 of the positions were up for election. You elect 2 new board, or the owners elect 2 new board members. And then one of the pitfalls a lot of associations do is at that annual meeting, then they just go forward and the board then elects officers for the following year. You know, the president, vice president, treasurer, secretary, et cetera. The kicker here is that at an annual meeting is a meeting of the members. It is not a board meeting. Again, 209051H requires the election of an officer to be held at an open board meeting. So if you plan to have the election of officers at the annual meeting, what you need to do is you need to send notice of your annual meeting for that night, and you also need to send notice of a board meeting for that same night. That way you adjourn, and so you'll have your annual meeting, have your election, whatever other business you need to do, adjourn the annual meeting, and then call the board meeting to order, and then go forward from there. And then it's at that board meeting that you will elect your officers. And I see a lot of questions flowing in. Again, I will get to those at the end of the presentation. This isn't a very long presentation, so I should be getting to them sooner rather than later. All right, let's talk about meeting minutes. Give me a second here to get a drink. So it's important to remember what the purposes of the meeting minutes are. So it's to record the acts of the board, to record why the actions of the boards were taken, and to preserve the approved resolutions and votes of the board. That, in a nutshell, that's what your meeting minutes are all about. That's what you're going to record in your meeting minutes. Again, I'm going to get much more in depth than that, but that's the 20,000-foot view of what your meeting minutes entail. So these are the required parts of the minutes: the date and the time of the meeting. You want to have the time that you call the meeting to order, the time that you adjourn. The purpose of the meeting, any issues about the purpose of the meeting needs to be included in the meeting minutes. Attendance record for quorum. So you want to note which board members are in attendance. Again, the quorum is a quorum of the board. It's not a quorum of the owners. This is a board meeting. So if you have a 5-member board, you have 3 members and 3 directors that are present. Make sure that you record which members are present to make sure to verify and confirm that you have a quorum in order to conduct the meeting itself. You want to have approval of the prior board meeting minutes, and you also want to include the adjournment of the meeting, and again, the time of the adjournment. So very important here, minutes should not be a blow-by-blow account of a meeting, but should contain resolutions and votes. I've seen some meeting minutes where it's like a court reporter was at the board meeting, just typing everything that was said and discussed, almost word for word. You don't want to have 10 pages of board meeting minutes. That's not necessary. You want to have enough information to detail what was discussed, votes that were taken, and that kind of thing. But you don't have to say, Mrs. Smith, argued this point, Mr. Jones argued this point, and it doesn't need to be. You don't need to have Jerry Springer minutes. It just needs to be, a brief explanation of what was discussed, and if there was a vote taken, and I'll get to that here in just a little bit, what that vote was. Actions that may be controversial should be explained. So if there's a hot button topic in the subdivision that the board is making a vote on, you probably want to use a little bit greater detail to kind of explain why the board took the action or vote or whatever, and kind of a little bit about the mentality or the thought process behind that particular vote. If a lowest bid is not selected, an explanation should be provided. That would just prevent, a little bit of meeting minutes in the front end will save a world of hurt on the back end, because it will be in the meeting minutes as far as why the board made a decision to go with a higher bid versus a lower bid. An extended discussion should be noted as the board discussed the issue of blank, just talk about that, and that kind of thing. But again, I can't stress enough, you don't need to, it does not need to be a word for word, stenography, I think is the right word, maybe not. I might have just made that word up. But it does not need to be a, word for word recitation of what was said at the board meeting. So now action on accounts. This is where I mentioned earlier in that list of 15 items that must be voted on and considered at an open board meeting. One of those was the initiation of enforcement actions. So I'll get to that in just a minute. Before I get there, very important, minutes are not protected by the attorney-client privilege and are discoverable. So if there's a lawsuit, if there's a records request submitted by an owner, those meeting minutes are subject to production. You have to produce them. You cannot claim attorney-client privilege. So very important to keep that in mind. Again, the meeting minutes are a record of what was done at the meeting, not what was said by the members. Never put opinion, favorable or otherwise, just keep it objective. Just kind of, it's just a explanation of what was discussed, what was voted on, et cetera, at the board meeting. Don't put in personal opinion, that kind of thing. That might get you into hot water later on, potentially. Don't put too much detail. And also, based on the topics that are discussed at the board meeting, have separate paragraphs. Don't have it just be one long run-on sentence. It makes it very difficult to try to locate what was said and where. So it's very good to, if you're talking about issues at the pool, that's paragraph 1. You're talking about, increasing the assessments, that's paragraph number 2, that kind of thing. Separate it out. You can even put little headings if you want, as far like assessments, pool, that kind of thing, if you'd like to do that. So again, for the meeting minutes, it's a summary of the motion that was made and seconded. It's the disposition of the motion. In other words, did the motion carry? Did it fail? Avoid using names if at all possible. Summary of committee reports. So you have your landscape committee gives a report. Put a summary of what was said in your meeting minutes. And then for executive sessions, anything any decisions or expenditures that were decided in executive session, they must be summarized orally and then included in the meeting minutes. So again, you got to be very careful of that. You don't want to go into too much detail because it was discussed in executive session. So obviously we don't want to, divulge any personal, private, confidential, information like that. So when you're summarizing what was any decisions or discussions in executive session, make sure you're careful not to put anything that would violate somebody's privacy or confidentiality. All right, so the initiation of foreclosure actions, again, this is one of those 15 things in 29051H. We recommend, now keep in mind, an association cannot disclose an owner's violation history or any amounts owed to the association or their payment history to the association. So what does this mean in English? That means I can't, in an open board meeting, we can't say, well, Mr. Jones at 123 Elm Street is delinquent to the tune of $1,000. So we're voting to turn Mr. Jones over to the association, or excuse me, to the attorney for collection activity. Can't do that. That's a violation of the property code. Same goes for, we're voting to turn Mrs. Smith over at 123 Elm Street for the mold on the exterior of a residence for deed restriction enforcement. Can't do that. You're violating the deed restriction violation history. All this is in 209.05 of the property code. So we can't identify by name, by address, or anything that would really give somebody an idea of who we're talking about. So what we recommend, there's a couple of things. And again, this is just for collection first. I'll get to the DRV second. The first is you can do it by account number. If you have a management company, the management company is assigned an account number to this particular collection account. You can reference the account number. The board, for example, the board approved the following accounts for foreclosure: 2017 1234, 2017 5678, that kind of thing. Or you can do it by reference to an amount due. The board approved all accounts for foreclosure with a balance above $1,000. That's fine too. And then you proceed through foreclosure per the collection policy. If you don't have a collection policy, that's okay. We encourage collection policies, but they're not required per the property code. You can just say the board approves to turn these over to counsel, legal counsel, for collection action up to and through foreclosure of the account. You can say something along those lines. That's just fine. So enforcement actions, again, we cannot reference a person's name or address. So again, we recommend using the account number for deed restriction violation turnovers to your legal counsel. One quick thing here. And so the requirements are in 209.06 of the property code. That also includes the 209 deed restriction letter requirements. But again, at an open board meeting, in order to turn a DRV account over to your legal counsel, it must be done during the open session. Do not reference their name or address, preferably use an account number. All right, your executive session. I can't stress this enough, guys. Do not take minutes during your executive session. I've had some clients that literally put a tape recorder on the desk and press record and record the entire executive session. Well, that recording that they just made, I guess I'm showing my age. I guess somebody could put an iPhone down and record it like that. But let's go my old school way. When you have a tape recorder, you put it down. And so that recording is now a book and record of the association. It's subject to production if there's a lawsuit and there's a discovery request, or somebody submits a records request for a book and record of the association, and they ask for the minutes from the executive session. You have to produce it. It's not attorney-client privilege. So for that reason, we say no minutes, no notes, pencils down. Do not take minutes during the executive session. Also limit any trash talk or gossip. You don't want to get accused of being discriminatory or arbitrary and capricious towards an owner, and stick to the agenda. It's a lot of times, especially if it's a hot button topic, board members can kind of go down the rabbit hole of get in the weeds of something. Really kind of stick to the agenda. Just keep in mind, typically the executive session is, well, it's not always, but a lot of times it's at the beginning of the board meeting. And so the owners are waiting for the board to come out of executive session. And the longer you keep them waiting, the more kind of disgruntled the owners may get. So again, stick to the agenda, move as swiftly as you can. Obviously, you want to take as much time as necessary to properly and comprehensively discuss what needs to be talked about. But just keep in mind that stick to the agenda, keep it going, get to that open session. So during the executive session, 209.051C talks about what the topics that are to be addressed during an executive session. Here's a list of them here. I'll read them just so everybody is familiar. Personnel, if you have association employees and you want to talk about the employee's salary or an HR issue or whatever, this is the place to do it. Pending or threatened litigation against the association, contract negotiations, enforcement actions. Now, the enforcement actions, again, you can have a discussion whether or not you want to turn somebody over to the attorney or your legal counsel. But again, the actual vote to turn that over must be done during the open session of the board meeting. However, you can have discussions about whether or not you want to turn it over in the executive session. Confidential communications with your attorney. Obviously, that's not something that we want to do in open session. So that can be done during executive session. Matters involving the invasion of privacy of individual owners. Again, as I mentioned earlier, an ACC appeal hearing, if an owner says, I want that done during an executive session, I don't want my dirty laundry being aired out as far as being denied my ACC request, you can do that in executive session. And that matters that are to remain confidential on the request of the affected parties and agreement of the board. So those are the items per 209 that can be discussed during executive session. Again, as I mentioned earlier, don't take minutes for the executive session. After you finish your executive session for 209 associations, you must summarize orally what was any decisions that were made or any expenditures that were approved during the executive session. You include in the minutes of the regular or the special board meeting, whichever may be, in general terms, and again, explain any expenditures that were approved. When including in the minutes, do not breach the privacy of individual owners, violate any privilege, or disclose any confidential information. That's pretty, elementary stuff. But again, a little reminder never hurts anybody. Lastly, we're going to talk about virtual meetings, especially with the advent of COVID and all that loveliness that brought on. Virtual meetings were very rare, as most of you know, but 2020 was a whole different ball of wax. And now we have a lot of associations using virtual meetings for board meetings and for member meetings, annual meetings. The virtual meetings, personally, my experience has been that there's been a lot greater attendance when a meeting is held virtually, because owners don't have to get dressed up and drive somewhere to sit in an uncomfortable cafeteria somewhere or school gym and listen to people drone on and on. They can sit at home, open their iPad, sit in their pajamas and listen. And when they get bored, they just turn it off and they're on their way. But it's good because it encourages more participation from the owners than we've seen historically. So virtual meetings are not the devil, contrary to some people's opinions. I think they're a good thing. I'm not saying in-person meetings are a thing of the past, but I think that virtual meetings definitely result in more participation, which is always a good thing. So anyway, going back to the authority for virtual meetings, the Business Organizations Code, Section 22.02 applies to condominium and non-condominium associations. So your single family, your townhouse, and your condominium associations, 22.02 applies to all of them. It authorizes virtual board member or committee meetings via phone, video conferencing, internet, or any combination. So you could have a conference call, you could have a Zoom call, you could have, any or a combination of those suffices and complies with the statute in the Business Organizations Code. It's specific to nonprofit corporations, and it does not include subject to governing documents language. What the heck does that mean, Eric? Well, what that means is there's some provisions in the state statutes that say, unless otherwise set forth in your declaration or bylaws or whatever, then you can do this. That qualifying language is not in 22.002, which means the condominium associations and the 209 associations have an absolute right to hold their meetings virtually. There's not any qualifying language in the statute that may be overridden by something that may be in your governing documents. So Chapter 209.051C2 also speaks to virtual meetings, but it only talks, first of all, it only applies to single family and townhome. And secondly, so in other words, it does not apply to condominiums. Secondly, it only applies to board meetings. This does not apply to annual meetings, but you have the Business Organizations Code gives you the right for annual meetings, so that's covered. So 29051C2 says that it authorizes board meetings by electronic or telephonic means if each board member may hear and be heard by every other board member. All owners in virtual attendance at the meeting may hear all board members. It's an important word there, the word hear. It does not say hear or be heard by the board. It says may hear all board members. You hear a lot of, I'm sure you guys have dealt with a lot of the pushback from owners about a Zoom meeting and, well, we can't say anything. We have a right to speak. No, you don't. Now, that being said, we encourage our boards to allow owners to speak, have an open forum, maybe limit the time for that an owner can speak during the open forum. Usually I find it's about 3 minutes. But if somebody starts spouting off, I have the right to speak at this, you can't stop me from speaking. Well, no, you don't have the right. You have the right to hear what all the board members are saying. That's what the statute says. And then the notice for the board meeting, if it's going to be held virtually, must include instructions for the owners to access the meeting, how it's going to be held. So if it's going to be a Zoom meeting, the board meeting notice needs to have the Zoom login information. If it's a Teams meeting, the Teams meeting. If it's a conference call, then obviously the call-in phone number for the owners to access the meeting. So is there a specific prohibition against a virtual meeting? Are we subject to our governing documents? Probably not. Again, 22.02 gives that authority. Should we amend the bylaws? Probably so. It really depends. I did a lot of bylaw amendments for my condominium associations, especially, because if you hold a meeting virtually, for 209 associations, absentee ballots are authorized per the statute, per 209. The same does not apply to condominiums. There is not a statute in 81 or 82 of the property code that authorizes absentee ballots. And if you're holding a meeting virtually, well, obviously there's no in-person meeting, so voting is most likely going to be done via absentee ballot more often than not. But for a condominium, you have to have that authority to do absentee ballots in your governing documents, typically your bylaws. If it's not in there, you can't do it. If you don't want to use absentee ballots, then I recommend you use a directed proxy. If you're not familiar with what a directed proxy is, get with your legal counsel on that, but that's a way around having an absentee ballot. Gets a little extra step there because you have the directed proxy, and then you actually will have probably one of the board members fill out the ballot, subject to what the directed proxy says. But you can use directed proxies if you want. And then what vote is required to amend the bylaws? Well, that depends. 22.102 of the Business Organizations Code says that an association through its board can unilaterally amend its bylaws unless three different things are applicable. One of the three different things are applicable. More often than not, they are not applicable, and the board, regardless of what the bylaws say, may very well have the ability to amend its bylaws unilaterally without a vote of the owners. Again, before you say, oh, we have the authority, we're going to amend the bylaws to say this, get with your legal counsel. Let them look at it, see, because there is some qualifying language that may be in your bylaws that, no, you can't do it unilaterally. You have to get a vote of the owners. So again, it's not a guarantee. Give with your legal counsel, see what your attorney says with respect to whether or not the board can unilaterally amend the bylaws. I believe that's it. So that is the presentation. Got through in about 32 minutes. Kind of proud of myself. Hope you are too. I know we got about a gajillion questions here. So let me go back to give me a second here, folks. I want to get to the questions. All right, chat. Holy smokes, we got a lot of questions. All right, here we go. Can you clarify single-family home communities? If we are required to list each individual account referred to the attorney for enforcement actions in the minutes, or we can summarize and add the total accounts approved for attorney enforcement action. Okay, so the kicker here is, in order to comply with the statute, we have to demonstrate that the association has, voted on and approved turning over a certain account to the attorney for legal action. That because if you don't meet that element of Chapter 209, then the owner is not responsible for any attorney's fees incurred by the association in that enforcement action, including the attorney's fees. So it's very important that whatever method you use to document turning over an account to your legal counsel, that you can draw or connect the dots to here at this board meeting on this date, this is where we authorized Mrs. Smith at 123 Elm Street to be turned over to the attorney. And I kind of went over this later on. This question was kind of 10 minutes into the presentation, so I think I've already addressed this. But if you have any questions on that, get with your legal counsel. But again, so long as you can, when you're looking at the meeting minutes, you can establish that yes, Ms. Smith at 123 Elm Street was voted on and approved to be turned over, then you're good to go. All right, back to increasing assessments and special assessments, regardless of the amount of increase. This has to be voted on in an open board meeting. Is that correct? Yes, Ashley, that is correct. If not in their documents on suspending rights to amenities, but now have it in 209 notice, can that work? No, you have to have the authority to suspend an owner's use of the common areas in your governing documents. If you don't have that in your governing documents, then you don't have the authority to do that. So you may want to consider amending your declaration to include that language and that authority. Again, it is going to require a vote of the owners in order to amend your declaration, but I would strongly encourage you to amend your declaration before you continue on with suspending an owner's use of the common areas. Just because it's in the 209 notice doesn't get you there, unfortunately. On the slide that shows the actions that require noticed meetings, I see that ACC appeals is inside of a different shape than the rest of the items. Is this done deliberately to differentiate it for some reason? Just to draw attention to it, Dana, because like I said, a lot of times that's one that's kind of overlooked. People just aren't aware of it for whatever reason. So it just drawing a little bit of attention to it. Even if it's 10% or less, let's say because, even if it's 10% or less, let's say an increase of assessments, because in my experience, typically the board will increase the assessments by 10%. But now that has to be voted upon by the homeowner in an open board meeting. Again, at a board meeting, it's voted on by the board. So long as in your governing documents, typically not all the time, it says that a board can increase assessments up to a certain percentage without a vote of the owners. If that's what your documents say, you can do that vote, but it has to be done during the open session of the board meeting. Regardless of yes, sir.
Hey, can you stop your screen share? That way everybody's not staring at that dark screen.
Sure.
Thank you, sir.
Sorry about that. All right, let me see. No, I can't see anybody. Cal, how's that? Is that better?
Yes, sir. Much better.
Can you
now we
see
can all
me?
see you. Yeah, we can all see you now.
Oh, great. That's no good. Sorry, guys. All right, next question. Is there anything now that does not allow a homeowner to run for the board of directors or vote, even if they owe a balance of assessments or violations? Or is everyone allowed to run no matter the balance is owed? Okay, a couple of different questions there, Lori. First of all, you cannot run for the board if you've been convicted of a felony or crime of moral turpitude in the last 20 years. You're automatically disqualified from running for the board. Or if you reside with a current board member, like if you're a spouse of a current board member, if you're living within the same household as a current board member, you are not permitted to serve on the board. So there's no reason for you to run. So that's as far as that goes. Now, if you are delinquent in the payment of assessments, if you have a deed restriction violation at your property, if you're in the middle of a lawsuit against your association, you are still entitled to run for the board. Those issues do not disqualify an individual from submitting their name as a candidate to run for the board. Again, felony, crime, or turpitude, residing with a current board member, then you're out. Is the board required to conduct an open session meeting if they are appointing a new board member due to a recent resignation? Yes. Does election of officers follow the same guidelines if under development under declarant control? No, it does not. In that 209051, there is, at the very end of it, there's only 4 things apply to development control. Out of those 15 things, there's only 4, and that's set forth in 209051H. So if you look in your property code, if you have one of these little books that we hand out, if you haven't got one, hit up Kyle. I think we still have some left. This is the property code 209 and some other sections of the property code in this little book. Very handy, but different things for developer control. These notes about officer election and filling board vacancies are in 209. So do these not apply to condos? That is correct. These only apply to single family and townhome associations, not condominiums. Should the secretary on the board always take the meeting minutes, or is that something the manager should do? I know the board members will always ask that I take them, not all, but most. There's not a requirement that, unless it's specifically set forth in your governing documents, that the secretary must take the meeting minutes. A manager can do it, that's fine, but they're often signed off on by the secretary. It's typically how it's handled. Can you clarify exactly what is discussed in an open board meeting regarding fines, foreclosures, etc.? Cheryl, I think I already covered this, but as far as fines, if you're going to levy a fine against an owner, you have to discuss that during the open session. Again, don't use names and addresses, use account numbers. So the board makes votes to levy a fine against account number 12345 for mildew on the exterior residence or whatever it may be. And as far as foreclosures, I talked about that already, turning over collection accounts to your legal counsel. Again, use a account number or a monetary amount, whatever method you choose to use that you can, again, tie back to that particular owner in your meeting minutes. That way you don't run afoul of 209. Can you include the board's meeting notice in the annual meeting notice? Arguably you could, but it might get a little wonky and confusing if you have one notice with both meeting notices on it. I would again, this isn't required, but I'd recommend having your annual meeting notice, your board meeting notice, and have them in the same envelope, mail it out to the community. You could do it that way. All right. What about if a board become absent, non-responsive to management, 3 board members only in a community, only one has become active again from being out of the country? Can we schedule a new annual meeting to solicit new board members to be voted in at any time? Stacy, that's kind of a little bit of a loaded question. Without having more detail, without having, reviewed your governing documents, I really can't give you a definitive answer on that. Generally speaking, I've had situations where I had a 3-member board, only 1 member was active and the other 2 were in the wind. And you gotta push forward. I mean, and so in that particular situation, we went forward with a board member to try to, get things done. But again, it's a case by case basis. Let me be very clear on that. So depending on what your governing documents say, depending on the specifics of your situation, definitely gives your legal counsel to determine the best path forward on a situation like that, because that could get sticky. You may, go forward, operate in the best interest of the association, only to have somebody challenge the validity of the decision that was made. So that's where, again, it's very important to get with your legal counsel to find out, what your options are. And a situation like that's probably going to be a risk assessment. Which path forward is least risky as far as having a challenge, meaning a potential lawsuit filed against the association? Board names should not be listed on the meeting minutes of who motioned and seconded. You can. I know I said that earlier, and I actually meant to delete that from the slide. You can include board meeting as far as who made the motion, who seconded the motion. I don't have an issue with that. What the slide should have said is the names of the board members are not required. All right. I'm confused now. Last week's seminar, I understood board cannot make decisions in an executive session. Just discuss the issues. Decision must be voted on in an open meeting, called back to order after executive session. Well, if this is the Gene Hamilton that is one of my clients, you're a condominium, Ms. Hamilton, and so there's different rules that apply. What I said earlier was to 209 associations. And again, that is the decisions in 209 there can be decisions made during executive session in 209. So that's a distinction there. Can you confirm why executive session should be done before open session? It does not have to be. A lot of boards like to do that. It can be the very beginning of the board meeting. You call the regular meeting to order, then you immediately adjourn to executive session, and then you call the executive session order, have your discussion, adjourn, and then start the meeting. Or in the middle, you call your regular board meeting. In the middle of it, something comes up like we need to adjourn to executive session. You can adjourn in the middle of the meeting if you want, or you can have the executive session at the end of the meeting. So you have your regular board meeting, and then once that's basically all the items are done, you're not going to adjourn. You're going to go into executive session, have the executive session come out, and then you're going to adjourn the board meeting. So there's no right or wrong there. Just you can have it at any time before, during, or after the board meeting, the open session of the board meeting, excuse me. Should the agenda be given to homeowners if we are doing virtual meetings? Yes. How to calculate the reserve requirement for a condominium association? That's a question you need to talk to your legal counsel about. Without having more information than that, that's a question for your attorney and probably your CPA, your association CPA. What 3 things are qualifiers for amending the bylaws? Ted, you got to ask me something that I don't have them memorized. But one of them is that for example, that the authority to amend the bylaws is vested solely in the members of the association. So for example, if the amendment provision in your bylaws say these bylaws shall only be amended by 70% of the owners of the association, some language like that. Well, that is language that is mandating that the bylaws can only be amended by the members of the association. A lot of bylaws say these bylaws may be amended by 70% of the owners of the association. We take the position that may is not a shall, so it's not mandatory, it's permisory. So in that situation, again, if one of the other two things isn't applicable, and forgive me, off the top of my head, I don't have those memorized. But again, it's in 22-102 of the Business Organizations Code if you want to look them up. And you can go online. The Business Organization Code is available free online. Or if you have one of our little books, it's in the book. Again, 22.102 of the Business Organizations Code will have that information for you. All right, next question. Does it matter when the executive meeting is held, before, board, or after? I just answered that question. What about an owner's right to vote versus use of common areas if behind on assessments? Okay, again, Ms. Hamilton, this is for condominium, it's different. What the answer I gave earlier, because the question was pertinent to single family residential communities. If your governing documents say that if you're not a member in good standing, you cannot vote, that is enforceable for a condominium. So again, it depends on what your governing documents say. If it says owner's not in good standing, and good standing is defined as being current on your assessments, not having any deed restriction violations, that kind of thing, yes, you can prohibit an owner from voting or from using common areas if your governing documents have that specific language. Can you clarify if all of the actions that require notice meetings applies to declarant governed communities? Mentioned that earlier. There's at the end of 209-0051H, there are the 4 things that apply to developer controlled communities. So I encourage you to look there. Again, the property code is also available online for free. You guys just Google Texas property code, you'll find the link. And again, for that particular question, 209.0051H. If an ACC hearing is held in executive session per the owner's request, does the board decision have to be voted on in the open session? No, it does not. In that case, you do not have to hold that vote in the open session because the owner specifically requested that it be done in the executive session. Do we have to send out notice for an ACC hearing if it is not being held during an existing board of directors meeting? For example, if we're having to schedule a hearing after we have already had a meeting, or if the homeowner does not want to have it during an open meeting. I'm going to go the beginning of your question says, do we have to send out notice for an ACC hearing? Again, one of the 15 things in 209-0051H is an appeal of an ACC hearing, which I assume that's what you mean by ACC hearing. So you may have to call a special meeting of the board in order to hold that ACC appeal hearing. So you can't just do it outside of a meeting. Again, it must be done at an open board meeting unless the owner requests it to be held in executive session. Then you would call, for example, a special board meeting, then adjourn to executive session at that meeting, and then hold the ACC appeal hearing at that time. Can you do an electronic vote 30 days before the open meeting for the special assessment, special amendment, and have that as the final vote at the meeting? It's going to depend on your governing documents, Lori. Again, go with your legal counsel on that. Without having reviewing your documents, I can't say yay or nay on that. Most likely, it would be acceptable, but if you're having it 30 days before a meeting, you may have an issue with the votes that are coming in. But again, I'm speaking generally. To be clear, I'm not answering your question. Give your legal counsel on that one. When sending an ACC appeal hearing notice, we usually post it on the website, posting agenda, and meeting location Zoom link. Do we need to send it to each homeowner by email, or is the posting enough? So for a 209 board meeting notice, there are 3 methods of sending out the notice. One is you can mail it, I think 10 to 60 days prior to the hearing or to the board meeting, which nobody does because of the cost. Number 2 is you post a meeting notice in a conspicuous location in the subdivision. For example, if you had like a bulletin board, like a physical bulletin board, or a sign with the letters that you put in, like you see in front of a restaurant, something along those lines. If you do that and you e-blast the notice to all the owners who have register an email address with the association. That's acceptable. Or you post a meeting notice on the website and you e-blast it to all the owners that registered their email address with the association. So those are the three methods: mail, posting conspicuous location and email, website and email. And the time periods are different. For mailing, as I said, it's 10, or believe it's 10 to 60 days. For a regular board meeting, the new law is 144 days prior to the meeting. You must send notice out. For a special meeting, a special board meeting, it's still 72 hours. All right. Our board is elected by the owners. Historically, the results of the election were announced at a general membership meeting, not at a board meeting. Is this an issue? No, that the results are typically announced at the annual meeting of the association. That's fine. At what point can we disclose to the homeowners that a board member is actively suing the HOA, that a lawsuit is pending? That's a sticky wicket, Angela. You know, again, if they file a lawsuit, that's public record. There's no real confidentiality there. You go to if you were in Harris County, you go to the Harris County District Clerk website. You can get a copy of the lawsuit that was filed against the association by the board member. But you got to be careful with that, because if you start announcing that and getting into detail, a couple of different reasons. One, the board member may accuse you of being defamatory or make allegations of defamation. Careful with that. Number two is you may end up revealing information or saying something that may be detrimental to the association's case in the lawsuit. So you got to be very careful with that. I would strongly encourage you, for any communications to the community with regard to a pending lawsuit against the board by an owner, or the association by a board member, get with your legal counsel to make sure that you navigate that minefield very carefully. What items can be decided outside of a meeting? Can decisions be made and then ratified at the next meeting? Again, 209-0051H for single family and townhomes. The 15 things in that statute are things that have to be done at an open board meeting for which proper notice is given to the owners. If it's not one of those 15 things, then it can be done outside of a board meeting. And then any actions that are taken outside of a board meeting must be summarized at the next board meeting and then included in the meeting minutes. Again, all this is in 209.0051H. So if you have a property code or get it online, check that out. It's all there for you. For condos, can married couples both serve on the board? There's no statute similar to 209 that speaks to that. So unless the governing documents prohibit that for some reason, that's okay. If 4 out of 5 board members resign, can the remaining board member appoint replacements? Yes, they can. Is it necessary to mention late fee charges in session? I assume that means open session, and know that 209.051H only says fines must be voted on, discussed during the open session. So if just a late fee charge, that's authorized by your dedicatory instruments, your governing documents, you don't have to vote on late fee charges. But again, make sure that they're authorized. If they're not in your governing documents, then you can't charge a late fee. If suspension of common area use, like the pool, has already taken place but not done so in an open meeting prior to the suspension, can the board do it at the next meeting so it's recorded in the minutes? I would go ahead and do that, that's kind of a belt and suspenders approach. I mean, the horse is already out of the barn at that point, but at least you have something to hang your hat on, that the board did consider and vote on this. And maybe such a challenge because the suspension was actually implemented prior to the decision by the board, but at least you have something to hang your hat on. Again, the toothpaste is out of the tube by that point. In order to impose a fine for violations, you would need a specific policy in place, correct? Yes, you would need, first of all, you have to have the authority to levy a fine in your governing documents, whether it be your declaration or your bylaws. If you don't have fining authority, you do not have the authority to levy a fine. Assuming you do have the authority to levy a fine, then we encourage our clients to adopt what we call a governing documents enforcement and fining policy, which sets forth, it kind of mirrors the 209 of the property code. Again, this is for 209, but it also applies to condominiums as well. You have to have the authority to levy fines. But yeah, policy is a good thing because it sets forth like a fine schedule, the amount of the fines per what the violation may be, if it's curable, non-curable, whatever the case may be. and the amount of the fine. You're welcome, Stacy. She said thank you. You're welcome. How to update amend restrictions. What if you have a large subdivision, 4,500 lots with 40 individual sections with separate but similar restrictions? How does the board facilitate updating or modifying restrictions? All restrictions indicate that they are changeable in part or in whole by the majority vote of the property owners within the specific section. How can restrictions be functionally updated? That's a tough one, because when you have that many sections, you're amending on a section by section basis, unless you're doing an amended and restated declaration and you're trying to consolidate all of them into one document. But again, you still have to get a vote of each section. You can't do it on a community-wide basis. So for a community that large with that many sections, unfortunately, Tom, that's going to be a very uphill battle to amend your restrictions in that situation. Because let's say you did the same amendment for each section. And let's just say it was a prohibition of short-term rentals, just one amendment. You have your attorney prepare 40 different documents, and 21 out of the 40 sections approves the amendment with the requisite vote. Well, that amendment is only going to apply to those 21 sections. Those other sections, the old restriction is still going to be applicable. Is there a time frame limit to host the board meeting for election of officers after the annual meeting? No, there's not. You just set the time, so, if your annual meeting is going to be, let's say at 7 o'clock and you anticipate a 2-hour meeting, then I would just say the board meeting is going to be held at 9:30 or whatever time after the annual meeting is concluded. Some are having executive session at end. Do they not need to disclose what was discussed? If they adjourn at the end, they are not disclosing that information into open session. You need to, once that if you're holding, so the question is, you hold your executive session at the end of your board meeting after the open session. After you are done with the executive session, you must come out of that executive session and then again go back into open session, summarize orally what was discussed or decided upon in the in the executive session, and then record in the meeting minutes. That's the proper way to go about doing it. All right, I've only got 2 more minutes, guys. I'm going to get through as many questions as I can, those 2 minutes. Thank you for sticking with me and listening to me blabber for a long time. If the board is able to communicate with each other during an open meeting without naming names or addresses using account numbers only, can they opt not to use an executive session? Yeah, that's fine. But again, just be careful with that you don't let something slip. Should members in attendance at a board meeting, should names be listed in the minutes? No, just the board members for quorum purposes. Now, if you want to include their names, you can, that's fine, but you don't have to. Can we deny repairs for delinquent owners? Well, it depends if we're talking about a condo or we're talking about 209. It depends on what your governing documents say. So unfortunately, that's a very open-ended question. I can't give you an answer on that. Is a multifamily 4-plex property governed by 209 single family? It depends on what your how your association was created pursuant to either your articles of incorporation or your certificate of formation and what your declaration says. So here, just look at that question. I can't answer without reviewing your governing documents. I'm sorry. All right, got time for one more question. What if the declarations specify an owner not in good standing cannot serve on the board? If that is a 209 association, that restriction is not enforceable, not valid. Now, if it's a condominium association, then yes, you can. But if it's a single family or a townhome association, cannot enforce that restriction because it's trumped by the property code. All right, there's several more questions here. I'm sorry, guys, I can't get to all of them. I don't want to keep you guys on here forever. Thank you so much for attending. I hope this information was helpful and useful. I will try to go back and hit some of the questions that were asked that I didn't get to. I can't make any promises, but I'll do my best. Again, thank you guys so much. I hope you have a wonderful rest of your week, and we'll see you next time. Take care. Bye-bye.